All right, well, let's get started. Good morning, everyone, and welcome to our February Equinox Focus event, The Value of IP in Your Business. I'm Michelle Bomberger, the CEO and founder of Equinox Business Law Group. I know a lot of you know us and are familiar with us, but just briefly, Equinox provides transparent, on-demand strategic legal counsel for business owners who are looking to do their own best work, get legal off their plate at a predictable fixed cost. So we really get excited to work with clients in that area. And today we're really happy to have John Odor with Chinook Capital Advisors join us to talk about the value of IP in your business. The structure for today's program is going to be, I'm going to go over kind of what is IP briefly, and then John's going to share some stories from his experience in the M&A market around how IP fits into deals and what you should be thinking about as a business owner or leader around IP in your business. A couple housekeeping items. We are recording this and it will be posted on our YouTube channel. You will also receive a copy of the recording via email. And if you have questions during the program, please feel free to pop those into the chat or the Q&A, and we'll try to address them as we go through. We do have a ton of information to cover. If we don't address the questions during the program, we will include an answer to those questions in the follow-up email as well. So we'll do our best to get to those, but sometimes time does not permit. So with that, let's get going. Just quickly, the legal disclaimer, we are not offering legal advice to any person here. Every situation is different. And I want to highlight here that intellectual property sometimes seems like a simple thing. There's online forms you can fill out and submit to the various agencies, but really it's a very complex area of law. So we encourage you to talk to an attorney before taking or refraining from any particular action with respect to your business. So what we'll cover today, what is intellectual property? So we're going to cover a few of the key areas that come up most often in business. How do you protect each one of those? And then what value does it offer to your business? And we're going to go through all of that in less than an hour. So here we go. So what is intellectual property? So creations of the mind used in commerce. I mean, the goal here is to foster innovation. And this is actually set in place through the US Constitution. Congress has the right to grant copyrights and patents. And so a lot of people don't realize that these laws sort of are part of our foundational legal structure within the country. But if we didn't have these protections, then folks wouldn't innovate. And so if we don't have people innovating, then we get stagnant. And so the goal here is to enable business owners and leaders to grow and build and innovate and have some confidence that they'll be protecting those assets as they develop them. So some of the key areas, we're going to go over each of these in 30,000 foot level detail. Copyright, trademark, patent, and trade secret. These are the ones that we see in business on a pretty regular basis and are really important for you to know what you have and what you need to do to tackle those. Generally speaking, the idea of intellectual property protection, it gives you the right to exclude others from using your creation. So that's the real benefit you get. You've created something, you've invested in it, you've built it, and you want to be able to control that. You want to be able to use it and capitalize on it in your business. And so the laws allow you to do that. That's really the core of what you get. So how do you protect it? There's a number of different tools. So by law, I mentioned the Constitution sort of is the foundational authority of Congress to be able to enact the laws. And then we have the US Copyright Act, and then we have state and federal trademark law, and then federal patent law. We also have state-based trade secret laws. So there's a myriad of tools out there that are legal tools, statutory tools that are available to help. The second is by contract, and this is an area that often gets overlooked in business, is that your contracts have provisions all the way through them, from assignment to confidentiality to inventions, all these things that you kind of maybe gloss over when you're going through your contract negotiations, but are really important in the function of protecting your IP. And then secrecy. So that's, goes to that trade secret concept. If it's something that everybody knows, obviously we're not going to be able to protect it very well. But if you have the tools in place through your management and organization, the understanding of what you have, then you can build into your company the ways to keep important things, what we call the secret sauce, secret, and enable your company to have some value based on that. So let's kick it off with copyright. So a copyright is an original work of authorship. So this is something that a creator has built, developed, authored. Usually includes books, music, computer programs, drawings, any kind of artwork that a creator builds and creates. The rights are granted to the creator upon the creation, and once it's put into what's called a tangible medium. Now, tangible medium has become a little bit, vague for a lot of people, because now we have all of these digital tools. So what is a tangible medium? And the law states that it's sufficiently permanent to permit it to be perceived and reproduced. It's not transitory. So being put into a software program that can be put into a CD-ROM or into some other digital tool is sufficiently permanent, as an example. So again, what rights do we have? We have the right to exclude others from benefiting from our creation. So if I create a logo, if I create a blog post, if I create a computer program, I get the right to exclude others from using it with my copyright rights, which again, come into effect as soon as I create it and put it in a tangible medium. I don't have to do anything else in order to have that copyright protection. However, there's a real benefit to doing more than just creating it and putting it into a tangible medium, but to really take those proactive steps to protect it. What are the tools available? Well, monitoring and enforcement is one. It is your job as the creator to monitor and enforce your rights. No one else is going to do that. Whether you're registered or not registered with your copyright, it is your job to enforce it. Some tools available, things like Google Alerts. There's software packages that allow you to scan the internet to see if you can see it elsewhere. And if you allow people to use it through a contract agreement, making sure that those contracts are enforced as well. So you don't want to lose your rights because you haven't enforced them. You need to take action. Within the federal registration system, the US Copyright Office is where you would register a copyright. And the benefit of registration is that it puts kind of a stamp of here's the date, here's the time, here's the content for your rights. So we can always say then, we have proof, we have a filing, we have a registration that gives us a particular date and time where we can say that's ours. And with that, you have greater rights for enforcement. So it's important to think about registration, and copyright registration is not particularly expensive or difficult. But if it's something that you want to make sure that you hold out to the public as a copyright of yours that you want to ensure you have protection over, registration is a great tool for that. Within your contracts, this is a really important area because, as I mentioned, the person who creates the work is the person who owns it. So if you're hiring a graphic designer or you're hiring a software developer, you're hiring a content developer, they own the materials they create unless they are explicitly assigned to you. So this is where we'll see inventions clauses and assignment of materials clauses, things like that, that explicitly say, yes, I'm hiring you to do this work, but it's mine when you're done. And if I don't put that in the contract, then it's not mine, even though I paid for it. So this is a really important area where people sometimes get in trouble because they haven't fully protected it. Another area with copyright that's become really interesting is in professional services, where I might have a number of tools that I use to deliver my services. And with those tools, I have implemented the knowledge that I've built over the years in my profession. And I might give a client those tools as part of the deliverables. And if the contract says that everything I create belongs to the client, then I don't have the right to use that again. And so there's been a lot of negotiation in some of these areas around, okay, pre-existing IP doesn't go to the client, or the client has the right to use or license certain parts of the deliverables, and then they own other parts of the deliverables. So if you are in kind of a knowledge-based business, or you're in a software business where maybe there's code that you use regularly, keep this in mind in your negotiations and make sure that you are retaining the rights to the things that are essential to your ongoing business, the things that are your own intellectual capital that you'll use over and over again. And then the last piece here on copyright, this question comes up a lot, is do I have to put those notices on there? You don't have to put the notice there, but it is a good idea to notify the public that you are claiming rights to that, that material. That way they know where to go if they want permission to use it. They know how to cite it if they're using it. And they know that it's somebody else's and whose it is. So these are important tools available to protect, protect your copyright content. One final point here before I jump off of this topic. Federal registration does give you greater rights to enforce damages as well. So that's just something else to keep in mind. All right, moving on to trademark. This is one of my favorites. It's an area that I practice in a lot, and it's all around branding and you know, building goodwill in your business from a branding standpoint. And so near and dear to my heart because I think it's a super fun area. Also incredibly complex. So what is trademark? Trademark is a sign capable of distinguishing one goods and services from another. So this could be words, logos, you know, colors, sounds, smells, but something that when the customer sees it, they can recognize the company that it comes from. The Nike swoosh is a great example that I use pretty regularly. You don't even need to see the word Nike. You see the swoosh and you're like, oh, athletic gear. That's it. And that's why that trademark is so strong, is that it is a visual that the customer associates with the brand and the quality of the brand and all of the characteristics of that brand just by looking at that item. So the rights of trademark are granted upon use in commerce and federal rights upon use in interstate commerce. So you have to sell something using that mark in order to obtain the rights. And your rights are granted within the geography and industry where you do business. So if you are only operating in Washington State, all your clients are in Washington State, then you would be more likely to look at a state trademark registration, and your rights would be limited to Washington State in the industry where you do business. If you expand and you're doing business in Oregon and Idaho and California, now you're in interstate commerce and you qualify for federal protection. Again, now you have national coverage within the industry services, goods and services that you sell. So for example, there are 3 deltas that I think I came up with. I'm sure there's hundreds of them, but we have, you know, Delta Airlines, Delta Faucets, Delta Dental, and all of these are national brands. So why can they all coexist? Well, because they're in different industries, and even without their imagery or their logos or their colors, just the words, the USPTO has deemed that a customer would not be confused to see an airplane with the word Delta and a faucet with the word Delta. And that the customer would go, oh, I didn't know that Delta Airlines is making faucets now. It's not something that customers would be confused about. And that's really the standard that they're going to start to look at when you file for protection. So we talked a little about the value, the right to exclude others from, you know, benefiting from this value you've developed. You know, if you see another company that's using your name in a similar industry, you know, your immediate reaction is they need to stop doing that. And the answer is probably yes, assuming that they didn't start using it before you, or if their work is very different than yours. And so there's a full analysis that goes around whether or not a cease and desist is appropriate in that situation. So again, how do we protect it? Monitoring and enforcement is a really big one here. We get cease and desist letters and send cease and desist letters periodically to folks who uncover companies that look a lot like them and aren't them. And so that's one tool. Again, I mentioned Google Alerts earlier on. That's a great tool to pop in your business name, and Google will let you know when it finds that name. Hopefully it's yours every time you get it, but every now and again it's somebody else, and you can look at it and say, that's fine, or wait a minute, I'm a little concerned about that one. For registration, I mentioned there's both federal and state registration. So federal is through the US Patent and Trademark Office, and then the state registrations depend on the state, typically through Secretary of State's office. And again, state registration is slightly different than a DBA, which would be through Department of Licensing. It gives you a greater protection with respect to damages because you've registered. But most companies don't go through the state registration process. It's not particularly robust. But if you're doing business in interstate commerce, a federal registration is definitely worth considering, and John will share a little bit later about kind of why that's true. Contract rights, similar to copyright, you want to make sure that if you are allowing someone to use your brand, use your marks through a contract, maybe it's a partnership, maybe it's a deal document where they have the right to use your name in their marketing, for instance, making sure that those rights are really clear, and if there's compensation for using those rights, like a licensing scenario, that those are really well laid out as well. So keep in mind, if you're allowing someone to use your marks under a contract, what are those protections you want to put in place? What are those limitations you want to put in place? Because your trademark represents your company. It represents the quality, it represents the style, the culture, and that is all really important to protect. And you don't want to allow that to have someone have free reign to use it as they wish. Again, the notice is not required. You will see a couple of different things with a trademark. You'll see the little TM. The little TM is an unregistered trademark. This is for goods, so products, or the little SM, which is an unregistered trademark for services. So what this does is it calls out to the public that you are claiming a right to this mark. You'll see this a lot with sub-brands. I've actually found it really interesting when you are at the grocery store and you look at the myriad of Procter & Gamble products out there. And a lot of their kind of sub-brands will have the TM and SM. And my guess is their strategy is that they change those pretty regularly, and the management of it is at a higher level. So they're managing the brands at a higher level and not every single sub-brand. But now that you've seen this, maybe you'll take a look and make your own assessment of why people use those versus going ahead with the registration. So if it's a registered mark, registered with the USPTO, you can use the little R with the circle around it. And you should use the R with a circle around it. It's not required, but one of the benefits of registration is that it's a public area where anyone who's using a mark should be going out to check. So they have a standard of, you should have known because I registered it. And if you're infringing upon it, then the damages are greater. So having this R with a circle calls that out for people and makes it really clear that this is a registered mark and they shouldn't touch it. So there's a real benefit in using that notice, even though it's not legally required, except for some of these benefits that you might get. All right, let's move on to patent. I will admit that patent is the area that I have the least deep knowledge of. It's a highly technical area. If you are looking at patent protection, I highly encourage you to talk to an attorney who knows this stuff inside and out, because you want to make sure you do it right. Why is that? Because it gives you the benefit of exclusivity for 20 years after your application. That's it, 20 years. So you want to be really careful about how and when and what that you do with patent. One of the most important things that you can do is to limit disclosure until you get your act together and get all these pieces teed up for your patent application, whether that's a provisional patent or a full patent. There are a couple different types of patent. There are utility patents, design patents, and process patents. There may be others. Those are the three that I've seen most frequently. And they require different pieces of information. Now we all are familiar with the idea of a patent being valuable to a business. It's an asset that you have exclusivity to. So if it's a product or a process, you would then have the ability to license it to others. We've run into entrepreneurs, innovators a lot who have no intention of building the product or selling the product, to either B2B or B2C, but they have something that's worth protecting that they can then license to others to manufacture and sell and obtain a royalty or some other partnership transaction for them. So the patent is one of those that may or may not be used in commerce right away. It's the invention itself. And then how you can monetize that takes a couple of different methods. And those typically fall into contractual relationships. So again, the licensing contracts are going to be really important in how to protect it. I didn't list that here, but that the contracts piece is essential to making sure that you have your own inventions and then any developments that someone else might make. How are those dealt with? So we want to be careful with that. Patent is also an area where the notice is required, and so you'll see something like patent number, pick the number. It can also have the form of PAT, or you'll see provisional patent or patent pending. You'll see those different forms of the notice, but they are required. Now, the challenge with patents is that you have to disclose the secret sauce. So when you file, you share the whole story, you share everything, because the point here is to say, I created this. Everybody, FYI, this is mine. And for 20 years, I have the right to use it exclusively. But what happens if we don't want to do that? Because 20 years isn't a whole long time, and if there's something super valuable in the commercial world. Well, that's where our trade secret comes in. And trade secret are those situations where you probably have something that's protectable and patentable, but you don't want to disclose it. And the classic examples are, Coca-Cola's formula, KFC's, 7 herbs and spices. But it can also be a process, a way that you do business that is unique and innovative. And that if you put it out there, either someone can, reverse engineer it, sub-engineer it, and use it. And so it doesn't make sense to file for the patent. So the trade secret law is state specific. It's a never-ending right to your business knowledge. And that knowledge has to derive economic value because it's a secret. So this is something that gives you a competitive advantage. And because it's a secret, you have the ability to compete better in the market. Washington State has what's called the Trade Secrets Act. So that's the specific law that defines what is a trade secret and what is misappropriation of a trade secret. So what value does it have? Well, again, John's gonna be able to share a little bit about this. When you go in to talk to a buyer for your company, part of your margin, part of that purchase price is goodwill, and goodwill fits into these different areas of benefit through your brand, through your processes, through your systems, through how you do business, and the trade secrets are a piece of that. So I encourage you to think about, what are the parts of your business that are your quote secret sauce, and maybe they're not even a patentable process, but think about them, because in the way of protecting it, you want to make sure that you are keeping it secret. So if it's a part of your full-blown employee training, then it's not a secret. Everybody knows it. If it's on your website, it's not a secret. Everybody knows it. So what does it mean for it to be a secret? And we see this language come up with non-competes specifically before the new law, but it still plays into the idea that if these things are disclosed, they cause the company significant damages. And they're causing them damages because it's a secret. And the way that any third party who's being sued is going to defend is to say, it's not a secret, everybody knows it. You train everybody on it. And that's going to take it out of the trade secret category. In the contract space, this really comes up in confidentiality. A lot of folks, again, will gloss over the confidentiality provisions in a contract. Oh yeah, those are the same. It's essential that your confidentiality provisions cover the things that are important to you. And you'll see often the kitchen sink, right? It's going to say, business operations, processes, customer lists, and it goes on and on and on. But make sure that the things that you know are your own trade secrets are listed in there, especially with respect to employees, contractors, people who have access to this. And you want to make sure that those are maintained confidential when they depart, while they're there and when they depart as well. So making sure that the right things are covered in that area. All right, so what did we learn? What value does IP have? It has the right to exclude others from using it. So this is exclusivity that you get by innovating and protecting those assets. The right to allow others to use it and to build on it, and that's your licensing rights. Ability to distinguish your goods and services. So you have a benefit. You can stand out because you have these assets, whether those are patents, trademarks, or copyrights. And you have the ability to obtain a higher margin. The idea that you have this IP that is valuable to your customers, valuable to third parties, allows you to sell your products and services for a higher price, allows you to sell your business potentially for a higher price. So I know we went through that at 100 miles an hour, but I want to turn this over now to John Odor of Chinook Capital Advisors, who's going to share some real world examples, specifically from the M&A space, but I think it applies to the everyday business space as well. So John, I'm going to stop sharing my screen and allow you to jump in.
All right. Let's see. Can you see my screen?
Yep, looks great.
Great. Yeah, so good morning, everybody. Again, my name is John Odor. I'm one of the co-founder, together with Ed Kirk, of Chinook Capital Advisors. And just briefly, we're a M&A advisory firm. We're based here in Seattle, specifically in Kirkland, and we focus on lower middle market clients here in the Pacific Northwest, Washington, Oregon, Idaho. Generally, our clients, their businesses are valued in a range of say $5 to $50 million, and we provide services to business owners, help them with valuation. What is your company worth today, and with business transition options, whether that's recapitalizations or business sale, and typically we work with clients years ahead of a transaction. So we're developing a relationship, we're providing thoughts on valuation, value drivers, and helping companies really to get ready for a transaction. So would welcome anybody that wants to reach out after the presentation. I'd love to meet you. I think, Michelle, you tackled a huge topic in a short period of time, and you raised just a number of great points. So I'll go through and just share some of my thoughts on really IP in an M&A context. So I think it's very relevant, and it's becoming more and more relevant. And if you think about intangible assets as part of the enterprise value of a company, it's I would say the percentage of M&A transactions where the intangible assets are a meaningful value driver is increasing. And I think if you think about technology, a hard asset, whether it's a building or a machine or something that you can touch, it's really not divisible. Where you look at intangible, it can be used by multiple users at the same time. So maybe the best example might be an app, right? So you create an app, and then you could have 1 million users, 10 million users at the same time. So the intangible assets can have tremendous value because you can have you can sell the same product over and over again without any or very little incremental cost. And I think that the standards around valuing businesses with physical assets and traditional EBITDA are well established, but valuing IP and the future value of that IP is there's really no one way to do that. So it's going to be unique to the situation, unique to the industry, and unique to the particular intangible asset, whether it's a trade secret or a patent or whatever. So when we talk about valuing the IP, these are very much high level conversation, and then really get into the fun stuff when we look at what industry you're in. I think the other the other thing, and this is really one of the main takeaways, if you have IP, you should really, your mindset should be that I have cash flow, right? And ultimately, any investor, they're just going to want to know how much free cash flow does this IP generate. And so if your business today is, let's say, a growing business and you're generating free cash flow from your IP, then generally your business is going to be valued as part of EBITDA. And so, if you sold your business for a 10 times EBITDA multiple or 20 times EBITDA multiple, effectively you're selling your IP as part of the overall enterprise value for your business. If your IP is not generating cash flow, then really the value of that IP is more in the future, and it's indeterminable today, but it could have future value. And so it comes around to how do you structure receiving the future value of that IP in the years to come. So I think that's one thing to think about is does your IP today, is it generating free cash flow, or is there a perceived value that in the future it could generate free cash flow? And just some statistics, say 20 years ago, the percentage of tangible assets versus intangible assets and market cap of public companies was much lower than it is today. So again, if you think of Amazon or Microsoft as very, very large market cap companies with relatively low tangible assets. I think the other trend in M&A is really defending patents, and there's actually a business around defending patents as well. So that's, I think, something else that's I think become more relevant in recent years. So we talk about valuation. There's really three fundamental approaches. One is the asset approach. It could also be called the cost approach. But okay, how much did it cost to buy this, or how much did it cost to create it, or how much would it cost to replace it? Right. This is probably the least relevant. The income approach is the most relevant. It would be really the future discounted cash flow of the IP, and what is that value today. The market approach is, well, what can we learn from what the market is willing to pay for something very similar that is already transacted. So if you can look at your IP and you can say, yeah, well, I know of 10 other very similar IP that have changed hands at a valuation of 1 times revenue or 2 times revenue, then you could use the market approach to establish the value of your IP. So you didn't know this, but Michelle's an entrepreneur, and she has a great idea. She's created this software for her. This is not a true story, by the way. So you can't disclaimer there. But yeah. But anyway, Michelle calls me and she says, "Hey, John, I got this great idea. I got this software. It makes law firms really efficient, and I think it's worth $1 million." And I said, "Oh, that's great." And we have a conversation about our IP, and Michelle, she really can't justify why she thinks it's worth $1 million, but she just has this gut feeling that it's worth $1 million. And so I have an invention here. It's made of a glass. It's a glass glass here, and I have a perceived value of this too, Michelle. And this is my perceived value is $1 million for this glass. So I'm gonna actually trade your idea for my idea, and then we can both be millionaires because we exchange perceived value. So that the point there is when you talk about IP, you need to talk about cash flow. You need to say this has, this is my cost, this is my margins, this is the number of customers, this is the amount of free cash flow that this IP is generating today, next year, year 3, year 4, year 5, and you really need to be on top of your business plan and your projections. And the more you can articulate that, the more tangible an investor is going to be able to create a meaningful valuation for the IP. And then just to touch base this on the market approach, there are M&A databases. So if you look at a particular industry, whether it's, it could be consumer products, it could be medical, it could be technology. And again, there's tens of thousands of M&A transactions. So, any M&A advisor, for your specific business, they would drill down into other M&A transactions that have happened and would be able to give you comps. And so again, for, asset light businesses that are highly valued, you could look at comps that are very similar to your business and get a feel for how the market is valuing that IP. The forms of consideration are really critical in a M&A transaction. If you think of it as a pyramid, the top of that pyramid is cash at close. Cash at close is good. When we represent our clients, that's what we aim for. And when we, negotiate with buyers, we really focus on cash at close. When the value of the IP is in the future, or it's going to be realized in the future, then that's when you're really looking at enterprise value that's paid out over time. And so that can be paid out through a number of forms. For example, you may say, well, I can sell you my business for say $10 million, but I'll finance it, right? I'll become the bank. So you don't have to pay me up front. You can pay me over time. That would be a seller's note. It could be an earnout, right? So it could be based on, future revenue, future gross margin, future EBITDA, and can be paid out over time. And then, when you get into IP that really is not generating cash flow today, then you may be looking at some sort of a royalty or some sort of a payment, like a revenue share agreement, or something not related to the revenue of the company or the EBITDA of the company, but something very much related to a specific IP, where you get a percentage of that revenue, or or a dollar amount each time it's used or sold, or whatever. So those can be part of that future consideration in an M&A transaction. So yeah, just a couple of case studies. Really the number one issue that a buyer is going to look into is, how have you documented your IP? And that was really, Michelle's presentation, right? Like, you need to, whoever is going to buy your company or invest in your company, they're going to review every scrap of paper that exists related to your IP. And, if you're missing signatures, if things aren't filed, if you're missing dates, you know, you know, if it's not in order, then it's going to create issues. And you know, we worked with a software company. They had created a software. At some point in their development, they had hired a contractor to help them develop the software. And in the contractor's agreement, it said that the contractor that the contractor was not giving the ownership of the software code that he had written to the company, and it became a major issue. Like, they had to go find that contractor, talk to him, and, you know, basically pay him to agree that they could have the free and exclusive right to the software so that they could sell it. So, you know, you know, you may just think, well, hey, you know, everybody uses this contractor, or everybody outsources this development, and this is the way it's done. But you really need to, you know, be on top of that early on, or it can bite you. The other example, we had a manufacturing business. This is in consumer products, and they had developed a creation. It was an idea that allowed them to basically improve their margins. It was, for example, it was taking 10 pieces that previously took hours and hours and hours to assemble, and it streamlined it into a single piece. And so they said that the perceived value of this product that they had created was very high, because once it's implemented, it's going to improve margins, have tremendous value. But in terms of today, you know, it wasn't reflected in their EBITDA and their EBITDA margins. So in this case, as part of the M&A transaction, you know, we had, you know, there was the enterprise value of the business. So let's say $10 million. Then there was a separate contract that said, hey, if, you know, based on the number of units of this future IP and how many units are used, let's say over the next 5 years, there was a scale of payments that would be made related to a specific IP in the future, because, you know, nobody really knew what the volume would be in the future. They didn't want to give it away, you know, for nothing in the M&A transaction, but it really had very little perceived value today because it didn't generate any cash. So just you know, again, a couple of examples. So just some quick thoughts on IP and an M&A process, and would welcome any questions either now or as a follow-up. And I'll stop sharing.
Great. So thank you. You know, the thing about the M&A side of this, I think, John, is that it's, you know, it feels so technical, right? And which is why we have folks like you to kind of help guide through that process. So when you're looking at, you know, the average business doesn't have a lot of patents, I would say. I mean, they're out there certainly, but not, you know, a lot of service businesses, a lot of retail businesses that may not have that. How would you recommend that they prepare what they have, or how they think about building value if they're going to sell in the future? You're on mute too.
It has to be said on every Zoom call.
It does. It does.
Bingo. Yeah. You know, ultimately, and this is really, you talked about it. How are you protecting your secret sauce? And, you know, whether it's a trade secret, a copyright, a trademark, or a patent, that, you know, it's something that you do and you want to exclude other people from doing it. So, you know, I love the KFC. I mean, what did you call it? The 7 spices. I mean, who cares, right? I mean, you can guess what it is. It doesn't matter. But they, you know, they created this aura that there is the secret sauce. And so I think, you know, the more, you know, this is the way, this is our process, this is what we do, and we do it alone, we do it better than others, it's exclusive to us. You know, I think, you know, and you can, you know, you can put, you know, secret sauce or branding around anything. And so I think that does create value because, if I look at, this is a company we're working with recently, it's management consulting, right? So, there's two ways you could go. You say, hey, we do management consulting. We're just like everybody else. We don't do anything differently. Or, hey, we do management consulting, but we do it differently. We have a specific process. We have an evaluation. We've developed this internally, it's our process, and we've kind of we've branded it, and that creates value because you have this way of doing things that nobody else does, and it can't be easily replicated.
Yeah, I think it's the day-to-day things that we do that we don't necessarily think about as being value added. I was talking to a business owner maybe about a year ago, small company, but over the years they have created tons of content around their industry, and that is what she knows that she has real value in selling, because the practice of the business is not is replicable. There's a few people in the market. So she was really intentional about what is this and how do I position the value of that to a third-party buyer, whereas many of us are creating content every day and not really thinking about it as a valuable asset.
Right. So one question I had for you, and this came up with a recent client, but it was they were developing software, and it was very specific to their client. Right. So they have a major client, and they were developing software for their client. And then there became this dispute of, okay, well, who owns the software? Right. I mean, they created it for their client, but they wanted to take what they had created and sell it to other clients. And then the client is saying, well, no, I mean, we help you develop this, and this is specific to our business, and we don't want you to make our competitors stronger. And it was, it was and then because it was their largest customer, they didn't want to get in a dispute with their largest customer over the issue, but at the same time, they wanted to take that IP and scale it with other customers. So I don't know if you have any comments on that.
Yeah, we run into that pretty often, and whether that's software or whether that's, as I mentioned, something like a consulting firm that has IP infrastructure, templates and spreadsheets and such that they might use regularly as part of their deliverables. I think the first line of defense is to go back on that assignment provision or that inventions provision and say, all right, there are pre-existing materials that we are bringing to the table that we get to use over and over again, and the stuff that we customize for you will be yours. You get the right to use the pre-existing materials, and you get the right to own the customized piece. So the stuff that I'm customizing for you that is your secret sauce and your specific processes, I promise I won't use that with a competitor. So that sometimes will do the trick. Right. But we have run into, especially in larger companies who know that they have power in the relationship, the desire for them to own all of it. And it's a real challenge, I think, for a smaller company, especially, that is, trying to play in that space and give and take enough, but not have to recreate the wheel when they are going to, other companies. So one way to do that, I think, is to productize the core. So can you productize the core and say, we are delivering to you, software X, which is our proprietary software, and you don't own that. And then you're going to pay us to, install, manage, customize, whatever, which is the pieces that you then own. So I think by productizing it, it sends a different message to the customer than just we're building this for you.
Right.
It happens to have some stuff in it. So that's just kind of one way to look at it, because I think a lot of it is the talking points to the other attorney and the other business people.
Right. Great. Yeah. Now back to Hillary and I guess the participants here. Are there any other questions that we could cover at this point?
All right. Well, if there are no other questions, I'm going to go ahead and share my screen here real quick, and we can wrap up. I guess I didn't need to go 1,000 miles an hour on my first part, but I hope you guys absorbed most of it. And John is available to answer questions. We will include this information in our follow-up email to everyone as well. Our next focus event is on March 18th, and it's going to be on effective workplace cybersecurity. It'll be a panel discussion covering insurance, cybersecurity risk generally, and legal issues around privacy and cybersecurity. So look for that one upcoming. We do these every month, generally on the third Thursday. That shifts a little bit from time to time, but we look forward to seeing you at a future event. And thanks so much for joining us this morning. Although I do see a couple things here that might be, nope, not questions. Thank you guys for joining us this morning, and we look forward to seeing you in the future. Have a great day.
Okay, great. Thanks, Michelle.